all rise. The Court of Appeals, Division 1 is now in session.
Good morning. You may be seated. We are here today on our matter number 1 CA-CV150536 FC, Alvarado versus Alvarado. Counsel, as you both know, I'm sure, we allow you each 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of your own time. We don't do that. The clock on the podium reflects the total amount you have remaining, including what you may have decided to reserve. We record these proceedings so when you approach the podium, and both times for the appellant, we'd be grateful to you if you would recite your name and the name of your client before you begin. We've reviewed the briefs in the case, the extensive record, and we've also discussed the case in our conference. So with that, you may proceed. Thank you.
Good morning, Your Honors. My name is Mary Boyd Henderson. I am a practitioner in Yuma, Arizona, and I represent Samuel Alvarado, the appellant, in this matter. Mr. Alvarado is incidentally here. He's sitting in the gallery. He's the gentleman in the blue shirt in the back. Mr. Alvarado was divorced from his former wife, Mrs. Alvarado, in 2008. In 2008, he received an order of what was then referred to as joint legal custody. That order was taken away from him summarily in May of 2015 by the trial court, we believe mistakenly, following what could only be described as an unusual post-trial proceeding. There was no request to remove Mr. Alvarado's custody rights. The appellee never requested that. It was never briefed or submitted pursuant to ARS 25408. It was simply done by the trial court in the process of revising an order that she had entered a year before in June of 2014. The matter came before the trial court by Mr. Alvarado, who at this point, he had originally had 3 children who were subject to a child support order. At the time, he asked to modify that child support order. One of his children had already emancipated. The other was about to emancipate, and his youngest child was going to be the only one remaining on the child support order. So he sought an order to revise his child support. He sought an order to remove what had been included in the parenting time order as a right of the appellee to final decision-making authority, quote unquote. As we discussed in our brief, it is our interpretation and has always been our interpretation that provision was intended to be a parenting time provision, where in the event the parties were unable to resolve a dispute, the mother would have the right to make a final decision after consulting with my client, who maintained joint legal decision-making rights.
Explain what you mean about decision-making was intended to be a parenting time? Is that what you meant to say?
The language of the original order, Your Honor, was that both parties were awarded joint legal custody. It was an old order, so it said custody. One of the provisions of that order, however, also included a statement that mother could have final decision-making authority in the event there was a dispute between the parties.
But that didn't relate to necessarily a parenting time. It related to...
No.
Okay.
Yes, I'm sorry if I misspoke. I meant to say it was a part of the parenting plan, a provision of the parenting plan designed to address the statutory requirement that the court provide a means of resolving disputes between the parties as they arose. When Mr. Alvarado filed his post-decree motion, He did it at a time when his children were seeing him frequently. He alleged in his petition that they were spending equal time, if not more, at his home. And he requested a modification of the parenting plan, the parenting time plan, to reflect that equal decision-making or equal parenting time that he was enjoying, a modification of the child support, and a modification to eliminate that provision of the parenting plan giving mother final decision-making authority. We had a very extensive trial in 2014 over 3 days during a period of 3 weeks. The court heard extensive testimony, reviewed extensive exhibits, and the court entered a final order in June of 2014. The language of the order itself reflects that it's a final order, and there was no appeal from that order. Following the order, the appellee, through counsel, filed an alternative motion under either Rule 83 or what was at the time Rule 35D, which is either a motion for reconsideration or a motion for new trial. In that motion, she addressed the fact that the motion was not timely filed and said that if the court did not believe the motion was timely filed, that it should be treated as a motion for reconsideration. The court did indicate that it would treat it as a motion for reconsideration, and at all times did, in fact, treat it as a motion for reconsideration. There was never any request by the appellee to treat it as anything but a motion for reconsideration. However, when that motion for reconsideration ultimately was granted, and ultimately there was a hearing, the judge went back and used that motion for reconsideration to enter an entirely new order. And it is our contention, Your Honors, that that new order was without subject matter jurisdiction on the part of the trial court, because there was no valid post-trial motion in front of the court that would permit such a modification. A motion for reconsideration does not permit the setting aside of a final judgment. It, by its own terms, cannot be used to replace a motion for new trial, which is unfortunately exactly what the judge did. And the fact that my client does not at this time have rights to legal custody of his children or legal decision-making authority now, we believe illustrates the wisdom of having finality of judgments and rules against permitting courts to go back later and change their mind. Because quite frankly, I think that the fact that the court mistakenly believed that there was a request to modify legal decision-making authority before it and made that mistake in determining that she meant to grant sole legal decision-making authority to the appellee when clearly there was no such request reflects the difficulties encountered by a trial court when trying to remember evidence, credibility of witnesses, and so forth from such a long distance in time.
Your point on there is that when the parties were litigating in 2014, father had no one was arguing that either parent should have sole decision-making authority. Is that your point?
That is my point, Your Honor. That's correct. Father had not requested any modification to the order allowing joint legal decision-making authority. Mother requested no relief with regard to decision-making authority at all. And I think the record reflects that mother didn't even really provide any testimony about decision-making authority or testimony related to father's request to eliminate that one parenting time provision permitting mother to make final decisions.
So father, so the second step is father did, as you just referred to, father did ask the court to remove the provision that gave mother final decision-making authority, impliedly in the result or in the event that the two were unable to come to terms.
That's correct.
What did father ask the court to do with that? Did he ask that he be granted final decision-making?
No, Your Honor. The only relief Father requested was that that provision simply be omitted.
Okay.
And that the parties have a regular joint parenting authority.
Okay.
I think with that, I would like to reserve the remainder of my time for rebuttal, if Your Honors don't have any other questions at this time.
Fine, thank you.
If it pleases the court, Alan Cook representing Bernadette Alvarado. I filed this date just a supplemental authority for the court, and I apologize for the tardiness. My mistake. I thought it had already been done, but it's 25-403.09.
Have you served this on council this morning?
Yes, Your Honor.
Thank you.
And it just supplements what's already argued in the brief, Your Honor, that anytime the court makes a parenting time order, it's supposed to amend child support. Whether or not, it doesn't even say whether it's requested, but the statute says it shall. So I know there's a case out there that says it shall doesn't mean shall, but I submit that with respect to children, it probably does. And so when they talk about this. Your Honor, the allegations made in the briefs that mother didn't admit any mistakes happened, and that's not true. I have mothers candidly admitted here, and I hope you let me call her mother. It's just easier for the record. That Rule 84 wasn't the right rule. Rule 83 wasn't the right rule. The previous motion for reconsideration wasn't the right rule to cite. We agree with that. On the other hand, we've also filed a motion to suspend the appeal and let mother go ahead and file the appropriate motion under Rule 85C1. And there are two bases under that, under which I think the same relief could be granted. So what I think, frankly, is that this is a place where the constitutional harmless error rule really should come into effect. I agree there's cases that say that you can't extend the time for filing a motion for new trial after the time has already expired unless you requested the time beforehand. I agree that as a general rule you can't, although there are exceptions to that even when there's no notice, plainly, and we've cited those cases to you. I have no explanation for why neither Mother's Counsel nor the court cited the court to the proper rule. But I think it's pretty clear that under Rule 85C, relief could have been afforded.
How is that so, given the grounds that Mother's Counsel cited in her motion, namely the court made errors in admitting or not admitting evidence?
Well, because, Your Honor, I think what happened here, and I think if fair reading of the transcript, and you do have to read it, but at least if you even just go to page 3 of the reply brief where Father's Counsel cites statements by the court, I think the court felt misled by what had been stated to it by the father about parenting time for the children. The implication being, and it's from the pleadings, if you look at the petition that he filed to modify, it says that fathers had greater than 50-50 parenting time. I mean, that's the allegation that he made. And but the court wouldn't let Mother's Counsel introduce the text messages with the child that basically refuted what the father had said. And in effect, what had been happening with these parties, that the mother had had the children about 80% of the time. And there was a brief period of time when the daughter had a fight with her mother and stayed with her father for a month or two. But other than that, and that's when he filed, apparently. But other than that, it wasn't true. The daughter generally didn't spend overnights with the father, and she would see him when she wanted to, and that's pretty clear from the record. If you look at all the testament, if you look at the exhibits, and we've attached copies of those exhibits that were subsequently admitted as part of the answering brief. So the bottom line is that I think the court felt duped by the father, and he was permitted to offer his text messages, but the court wouldn't let mother do the same. And court later realized, wait a minute, okay, I've made a mistake here. Okay, if you look at the record as a whole, you look at it in the entirety, which is what she stated, and you can see it in what's quoted in the reply brief itself. Okay, these are children that have been living primarily with a mother, visiting periodically with the dad, but they have not been following a 50-50 parenting plan, and it's inequitable to be doing what we've been doing. And the court also made findings that it was pretty plain the parties couldn't talk to each other, and so gave somebody decision-making, and the person that gave it to was the person who had authority to do it under the decree anyway. So even though the decree says they have joint decision-making, but when they don't agree, then mother's decision is controlling, what is that if not a de facto sole decision-making decision anyway? And I think that's really where the court went with this. It realized the mistake it had been made, but what it did was it called it a motion for reconsideration being dealt with instead of a Rule 85 motion. And I think under Rule 85, the court could have done this. Under Rule 85-1C, where you talk about misrepresentation of another party, I think that the court plainly, if you read what the court said on the record, it plainly felt that it had been misled by father. She calls into question. She says specifically in at least two places, cited in the answering brief. It says, among other things, that it really says the effect of the testimony really is that it brings into question respondent's credibility, and that has an impact as to how the court sees the case in its entirety. And respondent's position with regards to Nicholas's text with his father caused the court to question his credibility, to be frank. But that's what the court says. So although father says in his reply brief the court never said it was misled, I mean, I don't know what that means if it doesn't mean that it felt it was misled by the testimony. Otherwise, it wouldn't have done what it did. Now, when father says none of this was pled, that's not true. If you go back to their original filing in October 30th of 2013, it asked the court to modify parenting time and decision-making.
Did mother ask before the June 2014 order that she be granted sole legal
I don't think she
decision-making?
did, Your Honor. I don't think she did, but on the other hand, as a de facto matter, she already had it. And I think when one party raises an issue and asks the court to address an issue, I think that brings into play the full panoply of whatever the court deems is in the best interest of the children after hearing all the evidence. And plainly, in this case, the court reached the conclusion that this was a case where mother base essentially had that authority, and the court just said that she had it. Again, if the court didn't change that and left joint decision-making with mother making final decisions when they don't agree, that's de facto the same thing as a practical matter. There's no real substantive change there that I can discern. I did want to comment on some things that are set out in the reply brief that I didn't get a chance to respond to.
Before you go there, let me
Yes,
ask you
Your Honor.
one more question about the record. There was a skirmish at the conclusion of the proceeding in mid-2014 where father submitted a form of order to which mother objected,
Yes.
and father modified it, and then the court signed the modified order,
Yes.
which gave the parties joint legal decision-making, mother being the final decision-maker. Did she object to that form of order? Or did she object to entry of that order?
I'm not aware of an objection to that order, Your Honor. I'm also not aware of a notice of lodging of the order other than it says that in the reply itself. But putting that aside, I don't see where that makes a difference. I don't understand this, frankly, where the argument by father is I lost my decision-making rights. Well, under the original decree, by their agreement entered in 2007, that order in 2014 said the same thing that the original order said, which de facto gives mother the right to make the decision when they don't agree. And so it's not, in that sense, a 50-50 decision-making item. I think what it does is it says the practical effect of that is that mother should consider what father has to say, at least listen to what he has to say about things. And I don't know the extent to which that's a significant issue in this case, especially given that the elder child, the middle child, the daughter, has now, I think, graduated from high school. So there's really only Nicholas left that would be subject to a support order.
Okay.
But I do want to say this. I want to make sure I get this from the court. This is not the case where you can just say we're vacating the order, go back and do something else, or reinstate the June order. These children have been living principally with mother. They were, in fact, before this case was filed. They were living with mother 80% of the time. And the child support order that the court made was in accordance with the guidelines, and there has been no argument whatsoever from father that the court has improperly calculated the child support figure based upon the parenting time orders. And so that's the life they have been living.
Say that again?
There's no argument that I found where anyone has said that the court miscalculated child support, assuming that the parenting time and the incomes are correct, that the court used to calculate it. Under the child support guidelines and ARS 25-320, the court is supposed to calculate child support, and it's based on the two principal factors are the incomes of the parties and the parenting time division.
Based on parenting time.
And-
One thing that confused me is
Yes.
the June 14 order that the court entered provided thought it was 78 days of parenting time, although in the text of the order, it said
Equal. Yes.
So what's up with that?
Well,
What do we make of that?
the figure calculated was actually based upon equal time, the figure, the $208. When the court went back and redid it using the correct figures, it was $1,130. It says it has a parenting
That's
time
what I
date,
mean to say.
but if you look at the bottom of the order, it says based on 50-50 time or whatever. That's my recollection of it, Your Honor. I'm not looking at it, but I also didn't do the case below. But that's my recollection. But when the court went back and calculated support in accordance with what they had been doing, what the court found at this second hearing, and what mother said they'd been doing before, except for this one time when the daughter was mad at mother and stayed with dad. But based upon that, that's what the child support should be. And nobody has said that that's a wrong number. Nobody has said the court calculated that incorrectly. But given the fact that that's the life they have lived, up through and including the present, then it would seem to me, whatever orders the court makes, if you reverse this decision-making thing, or if you reverse send it back for parenting time, I don't think you can't undo what they've lived. And that I think equitably, under the laws of the state of Arizona, mother's entitled to the appropriate support for the parenting time that she actually has the children. Now, I would tell you this isn't evidence. A lot of things have been said that aren't evidence. But the fact of the matter is, this is a very common problem in Arizona that the courts apparently aren't even aware of. It's very often the case that one parent or the other, and typically it's fathers, give up parenting time in exchange for money. If the child support's this, then you can have them however much you want. Happens all the time. I wouldn't say in every case, but I'd say there's a big number of cases where this happens. And so mothers very often will give up money in exchange for having the kids because they think it's in the kids' best interest or whatever. So I think whatever orders this court makes, and I understand there's a very wide range of orders you can make, but whatever orders you make, mothers shouldn't be required to disgorge child support that's been used to support the children during the period of time when she's actually had them, this 80% of the time. That, I think, plainly would be inequitable. And,
What authority is there for that?
well, Your Honor, there isn't any. Okay? The reason there isn't any is because I don't think anybody's ever argued it before. And I'm not aware of anybody having argued it. But on the other hand, under the authority, I would say, is the public policy of the state of Arizona, is that children should be adequately supported. And toward that end, the state of Arizona, like all the other 50 states, have come up with child support guidelines that tell the court how to calculate it and as a presumptive, fair way to make a child support order that can be rebutted by other evidence. And the court can make deviations if it wishes under the guidelines, but the fact of the matter is, this is a procedure that's been set up in order to ensure that children are adequately supported. And so given the fact that mother has actually been the person actually supporting the children 80% of the time, I would submit to you it would be inequitable to say that that order should be changed as of this date.
Let me ask you, I'm just going to go back here a bit. The June or the 2014 order specified equal parenting time.
Yes.
And the June 2015 order specified 78 days or something like that.
Well, it specified what they'd actually been doing, Your Honor.
Okay.
That's the
All right.
difference. In fact, okay, I'll leave it at that.
Okay.
Yes.
And so father was obligated under the June 2015 order to pay a lot more child support, and I presume has been doing so.
I presume he has too, but that's based upon the actual living circumstances of the children, Your Honor, that pertained the period of time, including the period of time, the entire period of time, except for that 2-month block when the daughter was angry with her mother.
And your concern is that whatever happens here, the consequence should not be that the trial court orders mother to pay back father for child support that he's paid at a level that accurately has reflected what has been going on.
That's correct, Your Honor. Now, with respect to, keep in mind, this petition was served in November, I think, of 2013, and the court could have gone back to December 1 of 2013 under the rules and the child support guidelines, any request to modify. But on the other hand, as an equitable matter, I think child support orders should be based upon the actual parenting time, not just what the order says. Now, I understand the reason for the order, but the fact of the matter is, when people have an order that says 50-50, but the kids end up living with one parent 90% of the time, then that parent is bearing the other parent's burden of supporting the children unless the child support accurately reflects it. That's just the fact of life. And it is a problem. It's a problem in the system itself. But that's a different issue, except to the extent that whatever orders you make here, even if it's just an order to have the Superior Court determine which child support figure should be in effect based upon actual parenting time, fine, whatever, if you're going to reverse it. I don't think you need to, though, for the reasons set forth in the answering brief, and I understand the public policy in favor of citing the right rule. I've got that. I understand that. I also understand, we've got a harmless error rule that in the Constitution of the state says, if they'd cited the right rule, we wouldn't be here arguing this today. Somebody might be saying the court abused its discretion, but I don't see how, based upon the evidence. I think the evidence supports what the court did. I would like to say a couple of things, though. I made some notes about the reply brief because I didn't get a chance. I've got 4 minutes, and I would ask if I can have a couple extra minutes if necessary. I understand it's discretionary with you. I would tell you, with respect to harmless error, the one we're relying on is the Constitution of the state of Arizona, and that's set forward Article 6, Section 27, as opposed to Rule 86. And I think that the Constitution rule trumps the court rule. With respect to prejudice, and they're alleging that the appellant is prejudiced by these orders, I would submit to you there's no prejudice in paying an appropriate amount of child support. I would say to the contrary, the record indicates these children have been living with mother 80% of the time, and the order should have gone back to December 1 rather than just effective June 1 of 2014. So if there's any prejudice, the prejudice is mother. She's the person who's taken it. The counsel says, or the appellant says, that Rule 81D doesn't require the clerk to send out a minute entry when a judgment's been signed and recorded. Technically, it doesn't say minute entry. It says give a notice of the entry. The clerk has to give a notice of the entry. Well, that's typically a minute entry, but Rule 81D does say that. In the reply brief at 9, they take issue with the use of the word misconduct. I think my use of the word being misled, court being misled, is based upon the quotes that show up in the reply brief itself, where the court felt that father had not been candid and called into question his credibility. And that's my conclusion based upon my reading of the transcripts. I would ask that you draw your own. Also regarding prejudice, I would ask that you read the reporter's transcript of 4/7 of 2015 at page 6, lines 10 to 15, where the appellant's own counsel states that the court found prejudice. So even though she argues in her brief that there was no prejudice, she argued it to the court itself that the court had found prejudice, and I think that's accurate. In the reply at pages 9 to 10, we're talking about vacating the child support order, and I've addressed that previously, so I won't address it again. With respect to the reply at pages 10 to 13 in decision-making, again, I'd just say that his argument is a distinction without a difference. The order that was signed in May of 2014 left the mother as the tiebreaker, and I don't see any substantial difference between that and mother having sole decision-making. I don't see how it is, and they haven't explained how it is, and I don't get it. So I'd be the first to say that. Other than the fact that it says something slightly different. The words are different, but the practical effect is still the same. Regarding the reply at 13 to 15, the argument about misled, I've addressed that previously. But I would say the entire tenor of the court's remarks is reflected at this page 3, bring into question respondent's credibility. And I think that's what the court felt by misled. Regarding the reply at page 16, I would say there is zero evidence that the child support order is inflated at all. They say that it's inflated, and I don't see where it's inflated at all. They haven't said how. They haven't said what's incorrect. They haven't said his income's incorrect or her income's incorrect. They haven't said anything about that. So,
Does the record say anything about whether father is current on child support now?
I don't know if he is or not, Your Honor.
Okay.
It was I think I have no reason to think he's not complying with the current order,
Okay.
and I don't know if he's paying on whatever arrearage would be created by that order or not. I don't know the answer to that. I'm sure Ms. Boyd has an answer. With respect to the reply at pages 16 to 7, there is no evidence in the record about what appellant actually believed about his child support obligations, whether or not he thought it was fair or not. So it's stated in the reply brief, but the record doesn't say it. And I would submit he's the person that asked for modification of child support, so I don't see how he can be heard to complain that the court modified it. The court doesn't have to modify it the way he wants. Once the issue's on the table, the issue's on the table. Also, reply at 19, the Court of Appeals can't restore the parties to their status and position prior. The court could make the order effective, but you can't restore the parties because the children have been living the way they've been living and their support has been paid as it's been paid. Pardon, Your Honor?
I'm going to have to ask you to wrap up.
Thank you, Your Honor. I just asked that mother be awarded her fees. Father's income is about $37,000 a year more than hers, and I would ask that she be awarded a portion of her fees and costs for being here. Thank you.
Thank you.
Again, Your Honors, if it pleases the court, it's Mary Boyd Henderson on behalf of appellant Samuel Alvarado. A couple of things that I think may have not been clear after listening to Mr. Cook's argument. First of all, the two orders that we're talking about, the 2014 order and the 2015 order, both provided the exact same court-ordered parenting time for Mr. Alvarado during the period that this child support order has been in effect. Both provided that during the period of this support order, Mr. Alvarado would be entitled to equal parenting time with his children. There is nothing on the current record. I'm sorry if I don't mean to cut you off.
But the 2015 order calculates child support based on 78 days.
Correct, Your Honor. We're talking about two different portions of the order.
Right. They're inconsistent.
They are inconsistent. The court orders that Mr. Alvarado is to have equal parenting time prospectively, but yet calculates child support based on a 78-day adjustment. So what my point was that Mr. Cook has talked as though there is a lengthy record reflecting what the current parenting time situation is between these parties. There is, in fact, no record reflecting what the actual exercise of parenting time has been since the issuance of the 2015 order. There have been no hearings.
Isn't that the point he's making, is that if this matter gets remanded, that he thinks the court should take that into consideration?
Well, I can't speak for his point per se, but I think that if it's remanded, the court would have to act within its legal authority and jurisdiction. And there was never a motion to modify filed with the trial court. The trial court undertook on its own to look over the entire record. I think the court's comments reflect that basically it just looked at the transcripts a year later and decided it had made a mistake. There's no record that the court looked at the exhibits or did any other investigation other than responding to this motion that had been filed.
So are you saying that if this matter gets remanded and mother, for example, files a petition to modify, that the court can or cannot retroactively consider what the living arrangements have been over the last 2 years?
I think that the court could consider what the living arrangements have been over the last 2 years, but the court would only have legal authority to make a child support order effective the first day of the first month following the filing of the modification pursuant to statute.
If this court were to vacate the 2015 order, that would presumably leave in effect the 2014 order. Father owed, and let's assume has been paying, significantly more under the 2015 order. If we were to do that, would father seek reimbursement of the amounts that he paid?
Well, I would imagine that father would seek some sort of relief with regard to that, because there have been several months now that he's paid an increased amount of child support that he, quite frankly, in his mind, should not have had to pay, and there's no record supporting his having to pay it. And so I think that he would ask for some sort of relief. What character that would take, I don't know, and I think a lot would depend on the grounds on which this court would reverse the order. I think that at any point in time, mother could have filed a petition to modify her child support post-decree. Even with this matter pending, there's no bar to her doing that. Any choice she has taken not to do that, knowing the deficiencies with the order that have clearly been pled and objected to all along, I think would be her choice not to have sought that relief. She could.
But the obligation to pay child support goes hand in hand with an allocation of parenting time. And I suppose to the extent that the parties have been acting as if the 2015 order is valid, in other words, have been allocating their parenting time with mother getting most of it and father getting 78 days and father paying comparable child support, it'd be hard to, well, those facts would need to be taken into account, I suppose.
And the court could hear those in connection with a new modification. What we're really, I guess, discussing is the effective date for the new child support order. And I would remind the court that mother had the right to appeal from the original orders and chose not to do that. The other issue that I had wanted to make sure that I addressed during my time was the issue of Rule 85C. The continuing statement that the trial court made a finding that father had committed misconduct is simply, I don't think, a fair reading of the court's statements. The court had a hearing that clearly began as though she intended to have a hearing on everything that had happened since the issuance of the 2014 order. After reviewing the rules and objections by Mr. Alvarado, the court limited that to just the consideration of those two text messages. Those two text messages do not reflect information sufficient to have undone all of father's testimony at trial. They related specifically to one particular event that took place during the period of the 3 weeks covering trial. Mother's motion was a request. Well, there were two requests. One, of course, the court denied, so I haven't addressed it. But the request at issue was that the petitioner felt she had been petitioner appellee felt that she had been treated unfairly by the court because Mr. Alvarado had gotten to introduce a couple of text messages that he had exchanged with the children during the period of trial. She had asked to do the same and was denied. She filed that, citing specifically a general sense of unfairness, a procedural unfairness, not any kind of misconduct, certainly on the part of Mr. Alvarado. And her motion itself makes no reference to that. In order for, I think the Davis case makes this clear, and the other cases cited in the briefing make it clear that in order for the trial court to have lawfully transmuted this motion for reconsideration into a Rule 85C motion, the motion itself would have had to state grounds under Rule 85C, and it clearly does not. The language specifically from the appellee's alternative motion was that the end result of the hearing, quote, the end result is the hearing was not fair on some fundamental level. Respondent was afforded to, the right to introduce intra-trial evidence. Petitioner was not allowed to do the same. And it goes on to discuss that procedural unfairness. That does not fit into any of the grounds of Rule 85C. And it can't fit into the catch-all ground because the catch-all ground requires, I want to get my quotation right here. extraordinary circumstances of hardship or injustice. And there's the motion doesn't even allude to such hardship or injustice. So the motion itself simply doesn't reflect grounds to transmute it into a Rule 85C motion. The court clearly has the right to determine credibility. Mr. Cook has addressed the court's single comment in which he indicated that Mr. Alvarado's testimony, that he questioned whether one of the text messages that had been admitted was really, in fact, authored by his child, caused her to question his credibility. And that is exactly the court's point, I think, at that in that exchange. The court at that point did not have the benefit of the trial exhibits before it. At least I don't believe the record reflects that it did. And the trial record of exhibits had significant exchanges of text messages between the children and both parties. Mr. Alvarado's testimony was that when he saw that text message, he questioned whether it was his teenage son's, because his teenage son does not punctuate that well.
I've got a question going back a couple of steps.
Sure.
What authority, what rule or statute under circumstances like this, if we were to vacate the 2015 order, what authority would allow your client to seek disgorgement of child support he may have paid over and above that which was ordered in 2014?
Your Honor, I apologize. I don't know the statutory number off the top of my head. There is a statute in Title 25 in the child support section that allows a party to go back and request judgment for overpaid child support. That judgment is not as nearly as good as a child support judgment. A child support judgment is highly collectible. You can garnish wages for it through wage assignment, not through wage garnishment. And there are several other advantages to having a child support judgment versus a child support overpayment judgment. But there is a procedure which would permit Mr. Alvarado to go back and ask to have credit for the amounts he's overpaid.
Okay.
I apologize, I don't have that citation.
No, that's fine.
I think that covers what I wanted to point out. Obviously, we object to the attorney's fees request, and we have requested attorney's fees on our part, and we do renew that request.
Thank you.
Thank you very much.
Thank you to both lawyers for appearing and for your briefs and for your argument. We'll take the matter under advisement and issue a decision in due course. We stand adjourned now.